Hello everyone, welcome back to yet another session on Meritshine Turbo, and the focus of today's session is to concentrate on the Companies Act. Acts itself are a bit complicated and there's a lot of legal terms and terminologies used, but if you try and understand the logic behind each and every statement that is given in the Act and you refer to the correct sections which are being mentioned while reading a particular section, it becomes a lot more easier to understand and decipher. Trust me, it's not that complicated. And it's also highly scoring if you understand why a particular statement has been made and what's the logic behind it, right? So every time you read something, try and spend some time to understand why or what was the thought process behind something. Because what it does is that if you understand things, memorizing them becomes a lot more easier in that context, right? So while there are certain things, because it's a bare act, obviously there are certain things which you will definitely have to memorize. But if you understand the thought process behind it, the memorization process itself becomes that much more easier, and that's what we're going to be looking at doing in all our sessions on the Companies Act. The focus of today's session is chapter number 3 of the Companies Act, and without further ado, let's jump into the session and start. Right, so when I look at this particular chapter, let's try and understand what exactly it entails and what exactly do we need to talk about. So when you look at chapter 3, it is basically referring to certain very important aspects, right? So when I talk about chapter 3, it essentially has two parts. The first one is basically your Prospectus and Allotment of Securities, that is part 1. And the second one is basically part 2, which is the companies and talks specifically about the private placement. So these are the two parts within chapter 3. So when I look at the sections overall, you have section 23 till section 41 in part 1 and then section 42 as far as part 2 of chapter 3 is concerned, which talks specifically into private placements, right? So what we're going to try and do is to consolidate chapter 3 into several questions and capture some of the critical sections as far as chapter 3 is concerned in the form of questions. So when I specifically look at each of these chapters within your syllabus, it's important that you understand what are the sections getting captured in each of the chapters, right? What is that chapter all about? So that if you have an understanding that, okay, chapter 3 talks about your prospectus and allotment of securities, then all the sections within that will essentially talk about that aspect only, right? And it's important that you understand at least the basic elements of what a particular section talks about. Because once you do that, a lot of things will get much clearer in your mind. Giving context to a lot of things in the overall bigger picture, understanding the individual sections and what each section is talking about makes a lot of sense. It becomes a lot more easier for you to understand things. So when I look at each of the sections, and obviously each of the sections will have their individual subsections as well, it's important that you know what the sections are, right? So in that context, when I talk about your chapter 3, what are the key sections that you're looking at? Your public offer and private placement, that is your section 23. So when you're talking about section 24, it is talking about the power of SEBI to regulate the issue and transfer of your securities. Then we're talking about section 25. It basically talks about the document containing the offer of securities for sale and to be deemed as the prospectus. Then section 26 talks about what are the matters to be stated in the prospectus. Then 27 basically talks about the variations in terms of any kind of contract elements or let's say the objects that are supposed to be there in the prospectus, right? Then 28 essentially talks about the offer for sale of shares by certain members of the company. And then 29 talks about the public offer of securities to be in the materialized form. 30 talks about the advertisement. 31 talks about shelf prospectus. 32 talks about red herring. So we'll cover a lot of these aspects. But what's important for you is to maybe run through each of these sections in terms of what's the heading, what is each section talking about. That becomes very important for you to understand, right? So when you talk about 33, it is the issue of application forms required for the securities. 34 talks about criminal liability for misstatement. 35 talks about civil liability, not criminal, right? 36 talks about any kind of punishment that is there for, let's say, fraudulently inducing persons to invest money. Then what is the punishment for that? That is covered in 36. 37 talks about action by the affected person. So if you committed a fraud, then if somebody else is affected by it, what kind of actions are they allowed to take? Then 38 talks about any kind of punishment for any kind of impersonation. So let's say if you are allotted securities, right, and if you committed some kind of impersonation or fraud while collecting or gathering such securities, then you will be committing an act of personation. Then what is the punishment for that? That gets addressed in section 38. When I talk about section 39, it's talking about the allotment of the securities by the company. Then section 40 talks about the securities to be dealt with in the context of the stock exchanges where they will be registered. right? And then section 41 talks about your global depository receipts. And as I said, section 42 as part of part 2 of chapter 3 talks about private placements. So this is in a nutshell what chapter 3 talks about, which is your prospectus and allotment of securities in part 1 and the company's private placement in part 2. Let's focus on this session on understanding each of the sections and some subsections in the context of solving some questions. So let's look at the first question. It basically is asking you as to which of the following is or are incorrect, which means there could be multiple statements that are incorrect or there could be one. Now, if you read the question, what does it say? It says a prospectus issued under section 26 subsection 1 shall not include a statement purporting to be made by an expert unless the expert is a person who, right? So what is the qualification of an expert who is basically opining whether the matters to be stated in the prospectus? That is what section 26 in chapter 3 talks about. So what are the matters to be stated in the prospectus and what should be the expert talking about, right? In that context, who is an expert? That is the big question here. Now, if I look at the option, it basically goes on to say that expert is a person who's not engaged or interested in the formation, promotion or management of the company. Or it says has been engaged or interested in the formation or promotion or management of the company. Then it says has given his written consent to the issue of the prospectus and then has not withdrawn such consent. What is such consent? The written consent that he has given before the delivery of a copy of the prospectus to the registrar for filing, and a statement to that effect shall be included in the prospectus. And then option 5 talks about all of the above. Now, the big question here is if I go purely by logic, right? Option A and option B are contradictory, which means either of these options can be there. Both the options cannot be there because one is talking about not being engaged and the other is talking about has been engaged. One of these has to be eliminated. Now, if I purely go by logic again, when would be the opinion of an expert considered in the case of any scenario? When that expert is having an independent opinion and the view is in no way biased, right? So whenever the expert is someone who's engaged or interested in the formation, promotion or management of the company, and that is where you get things like what are called as your conflicts of interest, right? So you want an expert where there are no conflicts of interest whatsoever, right? That is the context, which means ideally that person should not be engaged in any of the activities of the company or the formation or the management of the company. Second, if it has to be a trusted independent opinion, then he has to give a written consent. And that written consent has to be filed along with the prospectus itself so that the registrar of companies knows that this person is genuine and he's filed his consent. That's again supposed to be very, very important, right? The other aspect is why is the written consent required here? The written consent is required because the issue of the prospectus is happening and this person who's an expert states that he's perfectly okay with everything that is mentioned in the prospectus. Now, if he has any problem whatsoever with something that is mentioned in the prospectus, then he has to ensure that such written consent has to be withdrawn before the copy of the prospectus reaches to the registrar, right? That's the context. So as a result, your statement A, C, D, all of them flow purely by logic in terms of maintaining the independence of an expert in terms of the opinion, right? See, what is the governing authority trying to do at the end of the day, right? So the most important thing is protection of the interests of the shareholders, right? So think of it from the context of that only. So when I talk about Companies Act also, at the end of the day, while it is governing companies, whenever there are shareholders involved, it has to look at protecting the interests of the shareholders. So A, C and D, all of them are thinking in that context. And option B is the only one which basically brings in a conflict of interest element. And that is why option B turns out to be my correct answer in this case, which is the incorrect statement in this scenario. Right? And I could have actually not even looked at C and D. I know that A and B are contradictory. So one of these two has to be the answer. And then if I purely go by logic, obviously option B has to be the answer. Right? And what is the correct wording here? It has to be has not been engaged or interested in the formulation. Basically, the portrayal of the statement is that neither was he engaged in the past, nor is he engaged now with the workings of the company. That's the context, and that is what is termed as an expert. This is basically your section 26, which is your matters to be stated in the prospectus. Okay, let's move on to the next question now. What does this one say? It's basically asking which of the following is or are true. Okay, it says if a prospectus is issued in contravention to the provisions of section 26, the company shall be punishable with what? Okay, so let's say if there is an issue in terms of the prospectus, in terms of what is to be stated in the prospectus, and if the company is doing something which is contrarian or not in sync with what has been told in section 26 of the Companies Act, then what exactly will happen to the company, right? So what are the options here? It says fine, which shall not be less than rupees 50,000, but which may extend to 3 lakhs. And every person who is knowingly a party to the issue of such prospectus shall be punishable with imprisonment for a term which may extend to 3 years. And it says every person who is knowingly a party to the issue of such prospectus shall be punishable with fine which shall not be less than rupees 50,000 but which may extend to rupees 3 lakhs. Right. So if I look at my options here, it's asking which of the options are true. If I again purely go by logic, right, there seem to be at least multiple statements which seem to be correct over here. So I am gravitating towards either option D or option E as my answer. Right. Now the only difference between option D and E is the option B. If I can figure out whether option B is true or false, then automatically my answer will be available to me. Right. Now if I look at option B, it basically says every person who's knowingly party to the issue of such prospectus which has some contravention in some way or the other basically will be punishable with imprisonment. So one of the important things that you need to understand as far as Companies Act is concerned is that it has slowly gravitated more towards a fine system rather than imprisonment for each and everything. A similar case to exactly what happened in terms of, let's say, the Foreign Exchange Regulation Act being repealed and you basically got the Foreign Exchange Management Act. So what was the difference there? When we talked about FERA, it was like till the time you prove yourself innocent, you will always be considered as guilty, right? And on the other hand, the portrayal as far as FEMA was concerned is that you are innocent until proven guilty. So what is the difference in these two contexts? The difference in these two contexts is by default, you're considered guilty and you have to prove your innocence. On the other hand, here the benefit of the doubt goes to the individual or the company, right? So you're innocent till the time you're proven guilty. So in that context, the regulations are definitely a lot more favorable for companies and the directors, board of directors, so on and so forth. That is what is basically leading to a movement of hefty fines, big fines, but a lesser enforcement of imprisonments overall, right? That is the fundamental difference in terms of what the earlier Companies Act was and the way Companies Act 2013 has evolved and lots of amendments that have come in subsequently, right? So whatever amendments have come in have had a lesser emphasis on imprisonment, but definitely a greater emphasis on fines, so as to ensure that you continue to put a severe penalty, but the penalty is not necessarily imprisonment. So that is something which you should ideally keep in mind when you're talking about the Companies Act. I'm not saying that imprisonment has been removed everywhere, but predominantly when you look at the amendments, imprisonment has been removed from a lot of places, right? So in that context, option B is the one which looks to be a little tricky for me because it is talking about imprisonment, right? And both the other options are basically talking about a fine for the company and the fine for every individual person involved, right? So in that context, I am basically inclined to choose option E, which is A and C. And that indeed is my correct answer, right? Okay, let's move on to the next question now. What does it say? This is basically about the section 27, that is the variation in terms of whatever is written in the contract terms or the objects in the prospectus. So that is what section 27 talks about. And with regards to section 27, it's basically asking which of the following is or are false, right? Now let's look at the question. It says, a company shall not at any time vary the terms of a contract referred to in the prospectus or objects for which the prospectus was issued. Okay. Now, there are statements given which are basically talking about any changes or variations in terms of the contract, right? Let's try and understand each of these options. Then it says, except subject to the approval of or except subject to an authority given by the company in the general meeting by way of a special resolution. Okay. Then it says, providing that the details of the notice in respect of such resolution to shareholders shall also be published in the newspapers, one in English and one in the vernacular language in the city where the registered office of the company is situated, indicating clearly the justification for such variation. Okay. Option C says, provided that such company shall use any amount raised by it through prospectus for the buying, trading, or otherwise dealing in equity shares of any other listed company, then it talks about the dissenting shareholders shall be given an exit offer by the promoters or the controlling shareholders at such exit price and in such manner and conditions as may be specified by the SEBI by making regulations in this behalf, right? Now again, if I go by pure logic, right, what does it say? If I'm trying to make any variations in my terms of contract, I should ideally be doing that only when I am passing a special resolution in a general meeting. Otherwise, I should not be allowed to do that. So this seems quite logical, right? If you look at the second option, if I'm making any changes, right, in respect to any such resolution that has happened, then it should also be in the public domain so that all my shareholders should know this information, which is why it makes a lot of sense to have it published in the newspapers. And the important thing to understand here is one is in English and second is in the vernacular language in the city where the registered office exists, right? So this way, any of the shareholders who are, let's say, local public who do not understand English, then they will also be covered. So this also seems to be a very logical option, right? Now, if I look at the option D, it again says if, let's say, I'm making any changes to my terms of the contract as per the prospectus, if there are any shareholders who do not like what I'm saying, so such shareholders are the ones who are dissenting, right? So if these shareholders are dissenting, then I will basically be giving them an exit offer and whatever be the exit price and let's say any such conditions that will be governed by SEBI again. So it makes a lot of logical sense for option D as well, right? The only option which I have a problem with is option C because it says provided that such company shall use any amount raised by it through prospectus for buying, trading or otherwise dealing in equity shares of any other listed company. अरे भाई तुमने पैसा बोरो किया है, तुमने पैसा लिया है पब्लिक से, तो तुम अपने कंपनी में इन्वेस्ट करोगे ना. You will invest it in your company. Why would you invest in some other company, right? So any other listed company does not make any sense. It should ideally be that such company shall not use any amount raised by it through prospectus for buying, trading and otherwise dealing in equity shares of any other listed company. Because then what you're doing is you're essentially trading, right? But this money that you're raising from the public is to be used for the purposes of a growth of your organization, growth of your company. You cannot invest that amount into anyone else, right? Ideally, if किसी और कंपनी में डालना है वो तो shareholder अपने आप भी कर सकता है ना. Why does he have to pay into you? So that is the logic that you need to understand. So if a shareholder is giving you the money, it is for the growth of your own company rather than the growth of any other organization or rather for investment into any other organization. And that is where option C is the incorrect option or the one which is a false statement. So again, purely by logic, I was able to identify this option as well. Okay, let's move on to the fourth question now. What does it say? Now this is again in terms of section 27 only, right? What does it say? Where the company has raised money from public through prospectus and has any unutilized amount of the money so raised, it shall not vary the terms of contract referred to in the prospectus or objects for which the prospectus was issued, except by passing a special resolution through postal ballot, and the notice of the proposed resolution shall contain the following particulars, right? So if there is a variation, what are the details that need to be mentioned when you're talking about the special resolution or the notice of the special resolution, right? It talks about the original purpose or object of the issue. Okay, why was the IPO or the FPO launched in the first place? Okay, then it says the total money raised and the money utilized for the objects of the company stated in the prospectus. कितना पैसा उठाया, how much money was raised and how much money was utilized, कितना पैसा use किया गया for the objects of the company which have been stated in the prospectus. Objects in the sense, what are the basic guidelines or the mission or the objectives that a company has. उन objectives को achieve करने के लिए, to achieve those objectives, what all are the statements that were there in the prospectus, that basically should be mentioned. The next one it says is the extent of achievement of the proposed objects and the unutilized amount of the money so raised through the prospectus. Okay, so kitna out of the existing objectives, kitna objectives achieve hua, or how many objects were achieved, and what is the unutilized amount left after achieving those objectives, that is should be mentioned. Then it says the particulars of the proposed variation in the terms of contracts referred to in the prospectus or the objects for which prospectus was issued, and the reason and the justification for seeking such variation. मतलब कुछ भी change हुआ, so you need to ensure that whatever are the changes, right, and the reason and justification for such changes should ideally be mentioned. Then the fifth one basically says the proposed time limit within which such proposed varied objects would be achieved, along with the details of the advertisement of the notice for getting the resolution passed. So when I look at the options here, again, if I go purely by logic, for any kind of a notice of the proposed special resolution, it definitely should carry the original purpose of the object of the issue. It should definitely carry the amount of money raised and how the money has been utilized, right? What are the achievement of the objectives and what is the unutilized portion? This should also be there, right? What are the changes that you're seeking, and then what are the justification for these changes? So all of these seem to be purely logical things that ideally any variation notice of the special resolution should carry. And similarly, the proposed time limit also makes a lot of sense. Ki kitne time mein the proposed varied objects would be achieved. So that also makes a lot of sense. But what does not make sense is when you're already passing the special resolution, why do I need to mention the details of the advertisement of the notice for getting the resolution passed? So that advertisement as a part of the notice itself does not make any sense, because anyway you will advertise and that notice will be there in the advertisement. Right. So the details of the advertisement being mentioned in the notice is like a chicken and egg situation. भाई पहले notice आएगा उसके बाद उसको आप advertise करोगे ना. How will you advertise before the notice itself has come? And carrying the details of the advertisement in the notice does not make any sense. Right. So which is where this portion, right, does not make any logical sense, which basically gives you an option that this is the one which will be eliminated. Of course, the proposed time limit within which the proposed varied objectives would be achieved is something that you would definitely want to tell. Right. So all of these options A, B, C and D is something that you would definitely want to inform your shareholders or your prospective shareholders. And within option E, the proposed time limit is something which will definitely be required. But the second half of option E is something which is not required. So all of A, B, C, D and the first half of E is what you would ideally want to mention in the notice of the proposed special resolution. And the second part of E will not be there, which obviously means that option E will become my answer. Great. Let's now move on to the next question. What does it say? This is basically talking about section 31, which takes into account your shelf prospectus. So when I'm talking about your shelf prospectus, what essentially does it mean? So shelf prospectus is a prospectus in respect of which the securities or the class of securities included are basically issued for subscription, right? And this could be spread over either one issue or there could be multiple issues that could be there, right? Multiple issues. When I say issue is referring to a public issue, right? Over a certain period of time, right? And when I'm saying certain period of time, it is usually curtailed at 1 year, right? And within that 1 year, whatever set of securities are basically issued, the shelf prospectus is good enough for those set of securities being issued, right? And what it means is that if you have a shelf prospectus, then you don't need another prospectus to be freshly issued for a new issue if you already had one issue in that year, right? So it is basically a single prospectus. If I want to talk about it, it's basically a single prospectus, right, for multiple public issues. That's what the context is, right? And of course, I mean, if you have multiple issues happening, there are some additional things that you will need to provide other than the shelf prospectus, but this prospectus is good enough for a certain period of time. That is why it's called a shelf prospectus, because you can pick it up from the shelf. That's the context. Now, there's another term which basically talks about your red herring prospectus. Now, what is this red herring prospectus? What does this mean? Right. So, this is basically a prospectus which will probably not carry complete information in terms of the complete particulars or the quantum or the price of securities that are included therein, right? It basically contains most of the information pertaining to the company's operations, right? And what are the prospects of the company, right? The good parts and the complete information being distributed, right? But does not include the key details of the issue, such as its price or the number of shares being offered. So such a prospectus is basically known as your red herring prospectus. That's the fundamental difference. So now that we've understood shelf prospectus, let's get into the specifics of this particular question. What does it say? It says, which of the following statements with respect to the information memorandum is or are true? So when I said that whenever you're issuing a shelf prospectus and there are multiple issues happening in that defined period of time, then every time there is a fresh issue, it has to be accompanied with an information memorandum. So you don't need to issue a fresh prospectus, but you definitely need to issue a fresh information memorandum, right? and this will become a part of the shelf prospectus itself. Now, what does that information memorandum carry is what this question is all about. Let's look at the options. It says information memorandum containing all material facts relating to the new charges created, which means we're talking about new securities, changes in the financial position of the company as have occurred between the first offer of securities or the previous offer of securities and the succeeding offer of securities, which means अगर एक ही इशू हुआ है इससे पहले, then that means first offer and now. अगर पहले already issues हो रखे हैं, then what was the previous offer and what is happening now? Whatever the changes have happened between the previous offer and now, that gets taken into account. That's what this means. Now, when I look at option B, it says information memorandum shall be prepared in the form PAS1. Option C basically says that information memorandum shall be filed with the registrar along with the fee as provided in the company's registration offices and fees rules of 2014 within 15 days prior to the issue of the second or subsequent offer of securities under the shelf prospectus. Right. So if I again look at logic, right, all the three options seem to be fairly correct. If you bring up a new issue, then the information memorandum should definitely carry what are the new charges created, what are the changes in the financial position. All of that is absolutely correct. So A definitely seems logical. Right. If I look at option B, I will need to know whether it is form PAS1 or something else. That is the only doubt over here. Right. If I look at option C, it says information memorandum shall be filed with the registrar along with the fee. This also seems to be logical. It talks about registration offices and fees rules of 2014. This also is the correct reference. And it says within 15 days prior to the issue of the second or subsequent offer of securities under the shelf prospectus. So the only doubt in this case is the number of days that is there. Right. So if I look at the structure, when I look at form, which is basically your PAS, the essential full form for this is nothing but your prospectus and allotment of securities. That is what your PAS refers to. Then I specifically look at PAS1. PAS1 essentially deals with the variation in terms of whatever has been mentioned in the contract. So any variations that are there, then that basically is a part of PAS1. Okay. Any changes that you make overall, right? Whereas PAS2 is the form that you would attach when it comes to your information memorandum, right? That's the fundamental change, which is where your option B is definitely incorrect. The other problem is the duration of the time that is mentioned. So overall, when I talk about 15 days and you're talking about a fresh issue of shares, usually the time limit is too less, and this is a slightly important activity in terms of filing the information memorandum, right? So you will need to give time to the registrar to be able to understand what exactly is the specific requirements that are there, right? So in that context, 15 days will not be enough for the registrar or the Ministry of Corporate Affairs to figure out what exactly has the changes mentioned in the information memorandum. So they should definitely get more time. So if the ministry or the registrar needs more time, so 15 days is too less. So it should basically be 30 days or 1 month, which is the correct answer in this case. So again, purely by logic, the funda is very simple, that any changes that you're making to the information memorandum will definitely require cross verification by the authorities, and authorities will always be given more time in that context, right? So as a result, 15 days is too less. So at least a month before the issue of the second or subsequent offer of securities is when the authorities should be informed. So in that sense, option C is also incorrect. So the only option which is correct is option A, and that becomes my answer. Okay, let's move on to the next one now. Again, we are still in the shelf prospectus only. It says a company filing a shelf prospectus shall be required to file an information memorandum, as we just saw in the previous question, containing all the material facts relating to new charges created and such other changes as may be prescribed, provided that where a company or any other person has received applications for the allotment of securities along with the advance payments of subscription before the making of any such change, so the company or the other person shall intimate the changes to such applicants, and if they express a desire to withdraw their application, the company or other person shall refund all the monies received as subscription within dash days thereof. Right? So when I look at this particular question, again, the basic logic here is I will not inconvenience my shareholders. So at the end of the day, all the governing principles of the Act will work on fundamental principles wherein, in terms of especially time, if you talk about it, then your shareholders should definitely get the benefit in terms of time. Obviously, the MCA or the registrar should also get the benefit in terms of time, right? So only the company and its board, or let's say the directors, they are the ones who would probably get a lesser dosage of time, right? That's the context, right? So in that perspective, ideally, the time within which this money should be refunded in case such applicants wish to withdraw their application, then it cannot be as long as 1 month, right? 21 days generally is not the accepted term usually, right? So the only possible options are A and B. And within the context of A, 7 days is far too less. So as a result, you're looking at 15 days within which the money will have to be refunded, and that is indeed the correct answer. If you look at the previous question, it talked about 1 month, wherein you're giving more time for the registrar or the MCA to understand whatever changes are being made in the information memorandum, whereas in this case, 15 days are given to the company to ensure that whatever money has been received, it needs to be paid back. And why is it only 15 days? Because in any case, whichever account was used by the applicant to deposit the money needs to be refunded into the same account. So it's not going to take so much time. So ideally, even 7 days should have been okay. But just to ensure that there is not too much of a tight window here, 15 days has been provided. And that indeed is the answer. Okay. Let's now understand what we have kind of read in terms of shelf prospectus and red herring prospectus, just to give you a bit of a more clarity. Right. So you've already seen that it requires you to file an information memorandum every time you're filing a fresh issue of securities within the time period for which the shelf prospectus is available. That's the context, right? And whatever are the changes that need to be informed. The other important thing is it will be filed in the form of prospectus and allotment of securities, form number 2, right? And it will be filed with the registrar along with the fee within 1 month, right? And every time you file a memorandum of information, that information memorandum along with the shelf prospectus will now become the deemed prospectus, right? So whatever information memorandum is getting added in this particular subsequent issue of securities, right? In that context, that information memorandum will get added to the shelf prospectus, and that will in turn become the new prospectus now. That's the context, right? So again, trying to understand the difference, the shelf prospectus essentially means a prospectus in respect of which the securities or the class of securities included therein are issued for subscription in one or more issues over a certain period of time without the need to issue another fresh prospectus, right? So you don't need to issue a fresh prospectus. Instead of that, you're issuing the information memorandum, right? Now, the next thing is red herring prospectus basically makes an appearance in section 32. And this is basically a prospectus which does not include the complete particulars of the quantum or the price of the securities included therein, right? And you need to file it with the registrar at least 3 days prior to the opening of the subscription list and the offer. So that's the fundamental difference between a shelf prospectus and a red herring prospectus. Okay, let's now move on to the next question. Right, so now we're looking at section 34, which basically talks about the criminal liability for misstatements in the prospectus. Right, now where a prospectus issued, circulated or distributed under chapter 3, because we are in chapter 3 right now, includes any statement which is untrue or misleading in any form or context in which it is included, or where any inclusion or omission of any matter is likely to mislead every person, okay, we're talking about every person who authorizes the issue of such prospectus shall be liable under section dash and chapter dash, provided that nothing in this section shall apply to a person if he proves such statement or omission was immaterial, or he had reasonable ground to believe and did up to the time of issue of the prospectus believe that the statement was true or the inclusion or omission was necessary. Which means criminal liability will exist for any person or every person who authorizes the issue of such prospectus, right? Unless he is able to prove that any such misleading statement or any such omission did not actually matter, right, or was basically immaterial, or he had enough ground to believe that till the time the issue came out, right, he had reasonable grounds to believe that the statement was actually true, right, or the inclusion or the omission was necessary. Unless this person is able to prove this, he or she will be liable under some particular section, right? So here, this is purely driven by an understanding of the sections. The chapter that we're referring to is chapter 29, and when I talk about chapter 29, the title of the chapter is miscellaneous, and within the miscellaneous section, when you look at 447, 448, 449, 450, 451, 452, 453. So up till 453, we're basically talking about different kinds of punishments that need to be laid out. While the chapter itself is called miscellaneous, there are sections from 447 to 453 which are catering to different kinds of punishments. Right? Even after that, if you look at it further, your section 454 also talks about your different kinds of penalty, right? And then there are other elements that are there as far as the section is concerned. Now, technically, this section is not a part of the syllabus, but one thing for us to understand is if a particular section or a particular chapter finds a mention in the chapters that are meant for our syllabus, then we need to cover those sections or those chapters as well, because you never know if there is a question that might crop in. So, if you look at chapter 3, section 447 definitely does get mentioned. And 447 talks about punishment for any kind of fraud that is getting committed, right? That is section 447, right? When I look at 448, it basically talks about any kind of a false statement that has been made, okay? That is section 448. Now, when I talk about 449, it basically talks about any kind of a false evidence that has been shown, like what is the penalty and the punishment for that, right? Then when I talk about 450, it essentially talks about any kind of a punishment when there is no specific penalty or punishment that has been given. So that is 450. So when I specifically talk about chapter 27, it deals with the National Company Law Tribunal NCLT and the Appellate Tribunal. Now within this, if I look at section 420, it basically talks about the orders of the tribunal, right? So the important thing for you to understand in this case is that while this kind of a question is a little tricky and a little difficult to answer, because then it would mean that you would need to remember the section numbers along with the chapter numbers. But the point is, at least you should understand, okay, what a particular chapter deals with. At the end of the day, if I'm trying to understand a particular act, if I don't know what particular aspect of corporate law is getting covered in which chapter or in which section, then there is no point in me learning the act unless I know what each section talks about or what a particular chapter at least talks about, because every chapter has a limited number of sections that it deals with, right? So you should at least know the overall context of every chapter. That becomes very important because there is no point in ratifying. You need to understand as to where the relevance comes in, right? So it's important as someone who's aspiring to join SEBI to understand where a particular chapter or a particular section gets applied, right? So in that context, section 447 essentially talks about any kind of a punishment that exists for fraud, and that is what is happening in this particular case. So it's not exactly a false statement, it's not exactly a false evidence. So essentially it's a fraud that this particular section 34 of chapter 3 gets categorized as. Now, which is where section 447 also becomes important for us, even though technically it is part of chapter 29 and it is not included in the syllabus. But because section 447 is mentioned in chapter 3, which is part of our syllabus, we need to understand section 447 as well, right? And technically, that is the answer in this particular case, which is section 447, chapter 29. Okay, let's quickly try and move on to the next question. So now we are moving into section 447 and trying to understand what exactly is the punishment for fraud, or what exactly does it mean, right? So in that context, let's look at the question. It says, which of the following statements is true? Okay, without prejudice to any liability, including repayment of any debt under this act or any other law for the time being in force, any person who's found to be guilty of fraud, okay, what exactly is the punishment? Now, when I'm talking about the fraud, if it is involving an amount of at least rupees 10 lakh or 1% of the turnover of the company, whichever is higher, and involving public interest, shall be punishable with imprisonment for a term that shall not be less than 3 years, but which may extend to 10 years, and shall also be liable to fine, which shall not be less than the amount involved in the fraud, but which may extend to 3 times the amount involved in the fraud. Okay, now if you look at the options, all of these appear to be quite big. So the key thing to understand in these kind of questions is, let's try and find out what is different in each of these options. If I know what is different, then solving them becomes easy, right? So it talks about 10 lakh or 1%. Okay, B also talks about 10 lakh or 1%. Here also it's 10 lakh, 1%. Here it's again basically 10 lakh or 1%, 10 lakh or 1%. So this is same across all the 5 options, right? Next thing that is different is this says which is higher. Again, whichever is higher. This says whichever is lower, whichever is lower, whichever is lower. So this is one point of differentiation. So what I need to understand is whether it is whichever is higher or whichever is lower. That's the first choice that I need to make. So technically, each of the options is talking about imprisonment, which means that that is not a choice that I need to make. So it is by default going to be there. Now, what is different is the duration of the imprisonment. Okay, if you look at this, option A says shall not be less than 3 years and can extend up to 10 years. Okay, then option B basically talks about imprisonment which may extend up to 5 years directly. Option C again talks about imprisonment which can be less than 6 months but can be extended to 10 years. Right. So similarly, option D talks about which may extend to 5 years, and option E talks about 3 years but which may extend to 10 years. Right. And the other thing, if you notice, is that each of them is talking about involving some kind of a public interest. Right. Look at each of the options. It is talking about some kind of a public interest being there, which means that the punishment, whenever I have general public involved, the punishment definitely should be on the higher side, right? That is one of the things that you need to consider. Next thing is the fine aspect, right? So when I say fine, it's basically talking about the amount involved in the fraud and 3 times that particular amount, right? Option D, it talks about 50 lakh. In option C, it talks about amount involved in the fraud and maybe extending to 5 times of the amount, right? And again, when I talk about option B, it talks about 50 lakh. Right? So basically, if you look at the fraud and the involvement of public interest, if I think purely by logic, so I'm trying to ensure that there is a higher level of severity in terms of punishment, which means the 50 lakh amount might not necessarily be significantly high. When I'm basically talking about a fraud, which is of the amount of 10 lakh or 1% of the turnover of the company, right? So let's say if you're talking about a reasonably good company, which is basically talking about an IPO or any such instance, then you would assume that this company would definitely have a turnover which is significantly high. Let's assume that the turnover is 100 crore. And out of that turnover of 100 crore, if you're talking about 1% of the company, it's hardly 1 crore. So a fine should basically be something which will lead or act as a deterrent so that such acts of fraud are never again committed, right? So in that context, when you talk about it, it basically looks like 50 lakh is too small an amount in that context, right? So what I'm happy about is basically talking about a fraud which will definitely lead to a fine which is not going to be less than the amount involved in the fraud. That's for sure, right? That statement makes a lot of sense to me. So in that context, your option B and option D get eliminated, right? The other thing that I'm worried about is, should it be 3 times the amount involved or 5 times the amount involved? So 5 times seems a little too high. So which is where 3 times makes a lot more sense. And generally, you're looking at variables of 3 that usually get adopted. So in that context, again, I'm not tempted towards option C. I'm looking at option A or option E. Now between these, if I have to choose, the biggest change is in terms of whichever is higher or whichever is lower. If you're, let's say, a company which is only 1 crore, hypothetically, think about it. Hypothetically, if I'm saying that you're a company which is only 1 crore and you commit a fraud, right? Then when I talk about 1% of the turnover of the company, then I'm essentially saying that it's only 1 lakh, right? And if I'm talking about an amount which is 10 lakh, since you're a small company, which means you'll get away with the fraud, right? So whichever is higher would mean that smaller companies will be able to escape from the situation. So in order to avoid such an escape, I will consider the fraud amount to be the one which is on the lower side. That makes logical sense, which is why if you look at this particular option, whichever is lower makes a lot more sense than whichever is higher. As I said, if you're a 1 crore company, technically, if I look at 1%, that amount would be 1 lakh. And if that 1 lakh, and I say that whichever is higher, then automatically you will not be considered in that bracket at all, and you will be able to escape. Right? That's the context with which this particular clause has been put in, wherein we say whichever is lower, so that any kind of a lower level fraud is also accommodated within this particular punishment. That's the whole idea. So which is why the answer in this case will be option E. Excellent. Let's move on to the next question now. Now again, I'm talking about section 35, and in this case, see the difference. It's talking about not the criminal, but the civil liability for misstatements in the prospectus. Right? So where a person has subscribed for securities of a company acting on any statement included or the inclusion or omission of any matter in the prospectus which is misleading and has sustained any loss or damage as a consequence thereof, the company and every person who, and it's basically asking which of these is incorrect, right? So the company and every person who belongs to blah 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 shall, without prejudice to any punishment to which any person may be liable under section 36, will be liable to pay compensation to every person who has sustained such loss or damage. Right? So what it tells is that, well, if there was a situation wherein certain people have prescribed to the securities of a company based on some kind of an inclusion or some kind of an omission of some important matter in the prospectus, right? And because of which such person sustained any loss or damage, then the people who are involved from the company's side, they will be liable to pay compensation to every such person, right? Now the question is, which of the following persons is actually liable to pay such compensation, right? The first one, that he or she is basically a director of the company at the time of the issue of the prospectus, sounds quite logical to me, right? Has authorized himself to be named and is named in the prospectus as a director of the company, or has agreed to become such director either immediately or after an interval of time. So when I say after an interval of time or immediately, it is referring to the issuance of the security. So that's the context, right? So this also seems logical to me. Then it says is a member of the company. Okay, we need to understand this a bit more. Then it says has authorized the issue of the prospectus. Again, seems very logical. And then it says is an expert referred to in subsection 5 of section 26. So we've already seen this. So this again seems to be quite logical, right? So even the expert is liable, basically. That's what is the thing that you need to understand here. So when I come to option C, it says he's a member of the company. And there are certain terms that you should ideally understand. So essentially, there are a few critical terms that you should be aware of. So one is, of course, member. The second essentially is your shareholder. The third one is, of course, a critical element called as your promoter. So what are the differences between these three things, right? So when I'm talking about a member, right? So this is basically the one who holds equity shares of that particular company, and his name has been entered into the register of members, right, of that company, right? And any kind of dividend that is declared by the company is distributed only to those equity shareholders whose name appears in the register of the members, right? So that is what a member of a company essentially means, right? When I talk about a shareholder, it basically is, in simple terms, is a person who buys and holds the shares of a particular company, right? Now, they become members once their name is entered into the register of members. So till the time their name is not entered into the register, they will be considered only as shareholders and not as members. Now, there are certain types of companies wherein, let's say, you have a company which is not limited by shares, but which is limited by guarantee. There are certain companies like that also, right? So in that context, where there is no presence of share capital, then their members in that context cannot be termed as shareholders. So essentially, purely logic also says that an ideal shareholder would definitely want his name to be available on the register of members, right? Only then he will be able to get dividend also. So in that context, you would think that logically every shareholder should become a member, right? But the point is, it's a process that needs to happen completely, and there could be omissions in that context as well from a company's side in terms of missing out on certain individuals or stuff like that. So at that context, if a shareholder does not find his or her name on the register, then essentially he or she will be a shareholder and not a member, right? That's the fundamental difference, right? So essentially, when I'm talking about a member, holds the equity share of that particular company, and his name has been registered into the register of members of that company. And obviously, all the aspects such as dividend declared by the company will be distributed to such members. That's the context. Now, coming to the third one, which basically talks about your promoter, is obviously the person who's the guide, who's the person who's fueling the business. He's the one who's given the start to the business, right? He's basically the entrepreneur. He's the founder, right? Majority of the board decisions are essentially controlled by him, right? And ideally, you would also look at him controlling a majority stake as well. You'd be the one responsible for raising the capital, right? Targeting your initial leads and chasing any kind of business opportunities, entering into contracts, so on and so forth, right? So essentially, in normal circumstances, you'd find that the promoter would be the one who is your majority stakeholder or your shareholder in that context, right? So ideally, if I have to penalize someone, I would not be penalizing the member of a company, right? Because essentially a member of a company is a shareholder and his name is present in the register, but what else is his fault? Nothing else, right? So the person that I'm looking at here is not the member of the company, it is basically the promoter, because he has all the inside information. So he should be the one who should be liable for any kind of penalty, right? That's the correction in this case. So again, purely by logic, I look at all the options. Only one which is a misfit in this case is option C, wherein it's basically the promoter of the company, right? So technically, when I say a promoter is also a member of the company because he also holds the shares of the company. But the point is, every member is not a promoter, right? While every promoter can be a member. So that needs to be the correct terminology here, which is every person who is a promoter of the company shall be liable to pay compensation. That's the context. Okay. So that's the answer in this case, which is option C. Okay, let's move on to the next one now. What does it say? Again, we're looking at section 35 only. No person shall be liable under section 35 subsection 1 if he or she proves. So technically, don't fault me here. This is the language that is present in the act itself, right? So ideally, it should have been he or she or he, but for some reason it's only in the male gender. So it's obviously assumed that he here refers to both he and she, right? So if he proves that having consented to become a director of the company, he withdrew the consent before the issue of the prospectus and that it was issued without his authority or consent. Okay. Now, basically what we're saying is, कौन सा बंदा है जो liable नहीं होगा? Who will be the person who will not be liable, right? The next thing is that the prospectus was issued without his knowledge or consent, and that on becoming aware of its issue, he forthwith gave a reasonable public notice that it was issued without his knowledge and consent. Again, makes a lot of sense, right? अगर issue हुआ है, and if he basically comes on to say that he was not aware of it and gives a reasonable public notice that दुनिया को पता चले कि भाई what has happened. Right? In that context, again, makes a lot of logical sense. Right? Similarly, he had consented to become a director and he withdrew the consent before the issue of the prospectus, then also he should ideally not be liable. Again, makes a lot of logical sense. Look at option C. What does it say? That as regards every misleading statement purported to be made by an expert or contained in what purports to be a copy of or an extract from a report or valuation of an expert, it was a correct and fair representation of the statement or a correct copy of or a correct and fair extract from the report or valuation, and he had reasonable ground to believe and did up to the time of the issue of the prospectus believe that the person making the statement was competent to make it and that the said person had given the consent required by subsection 5 of section 26, which is already referred to from the expert's context, to the issue of the prospectus and had not withdrawn that consent before delivery of a copy of the prospectus with the registrar and to the defendant's knowledge before allotment thereunder, right? So, one, he was a director, or let's say he decided to withdraw his directorship before the issue of the prospectus, sounds quite logical, right? Then, if he was not aware, then he's making the public aware that bas mujhe nahi pata tha, I didn't know it, right? So he's telling the public very clearly. That also makes a lot of sense. So he should not be liable. Then he's talking about the expert and saying that till the time the prospectus was issued, he was absolutely certain that the expert is definitely someone who is fair and reliable and basically clearly qualified under subsection 5 of section 26, and he had definitely not withdrawn the consent before the prospectus went to the registrar. So in that context, if he was very clear as a person that the correct expert was deployed, that expert gave the correct valuation, and that expert did not withdraw that consent, even then he should not be liable. But here, this statement itself looks so big, so I have a general intuition that this statement may be the one which is incorrect. Now, what is incorrect over here? Specifically, when I talk about it, this is an amendment that happened. So wherever you're talking about a delivery of the copy of the prospectus to the registrar, the amendment that has happened is that instead of delivery of a copy, everywhere it has been changed to filing of the prospectus with the registrar, right? So technically, since a lot of these things have become online, automated, so it has to be done online itself. So it's no longer a delivery or a physical delivery of a copy. The amendment basically talks about a filing of a prospectus with the registrar. So as a result, this is the one which in this case becomes incorrect. So if he proves that he withdrew his consent of becoming a director before the issue of the prospectus, and that it was issued without his authority or consent, and second, it was issued without his knowledge and he gave a clear public notice, in that case, technically this person should not be liable. Even C was correct. Just because of this portion, this becomes incorrect. So as a result, the correct answer in this case is option D, which is A and B. Okay, let's move on to the next question now. What does it say? We're looking at section 38 now, which basically talks about punishment for personation for acquisition, etc. of securities. Right. So when I say personation, it essentially refers to any kind of an impersonation or cheating that you're doing as a person who's subscribing to those securities. That's the context here. Right. So which of the following statements regarding section 38 is incorrect is what we need to find out. So any person who makes or abets making of an application in a fictitious name to a company for acquiring or subscribing for its securities shall be liable for action under section 447. Okay. Then it says any person who makes or abets making of multiple applications to a company in different names or in different combinations of his name or surname for acquiring or subscribing for its securities shall be liable for action under section 447. Okay. Then it says any person who otherwise induces directly or indirectly a company to allot, register or transfer securities to him or any other person in a fictitious name shall be liable for action under section 447. Okay. Then it says D, where a person has been convicted under this section, the court may also order disgorgement of gain, if any, made by and seizure and disposal of the securities in possession of such person, and the amount received through disgorgement or disposal of securities shall be credited to the issuer account. Okay. So when I'm talking about the liability, again in the context of section 447, because it's referring to the fraud, and this person, by launching a fictitious name or by making multiple applications in the same name or by inducing directly or indirectly to allot securities to him or any other person in a fictitious name, he's basically committing a fraud. Right? He's committing a fraud, even though it is not the company committing the fraud, but it is the subscriber who's committing the fraud. Technically, section 447 only applies here. Okay. The next thing that I want to check is if I'm finding that there is a fraud that has been committed, then basically the court may also order disgorgement. So when I say disgorgement, whatever gains that person made, right, by let's say acquiring the securities and let's say disposal of the securities or by sale of securities to someone else, then whatever is the amount that he's received through such disgorgement or disposal of such securities should ideally be credited back. The only problem that I have is that it doesn't necessarily get credited to the issuer account, but it basically gets credited to the Investor Education and Protection Fund. That's the fundamental difference here, right? Because technically That's a fund which is always brought in from the context of protecting the interests of your investors. Okay, so while logic in this case says that okay, the amount should have ideally been credited to the issuer account, but the thing is, we're not just talking about the securities being returned to the issuer, we're talking about any gains that this person has made. So technically, the gains that the person has made does not necessarily belong to the issuer, but essentially to the correct investor, right? Because he committed a fraud, he basically bought securities which should have ideally gone to some other eligible investor, correct? So as a result, that gain or that benefit of disposing such a security should have gone to some kind of an eligible investor, right? So in that context, whatever gains that have happened, the disgorgement of such gains should ideally be credited to your investor education and protection fund. That's the most logical thing to do in this case, rather than crediting it into the issuer account, which is why option D is your incorrect option. Let's now move on to the next question. What does it say? This is basically talking about section 39, which basically deals with the allotment of securities by the company, right? So which of these statements is true is what is being asked. Okay, again, when I look at these set of statements, it looks like these are common statements with minor differences here and there. So whenever you get these kind of questions, always look at identifying what are the key things that are changing in each of the options. So when I look at this, so it basically talks about the stated minimum amount has not been subscribed. So of course, the minimum amount when I talk about any kind of an issue is basically 90% that we look at. Okay. And then we're saying the sum payable on application is not received within 15 days, within 30 days. So basically 30, 30, 30, 30, and one option says within 15 days. And within 30 days from the date of issue of the prospectus. The next thing it says, the amount received shall be returned within 15 days, 7 days, 15 days, 15 days, 15 days, okay, from the closure of the issue. And if any such money is not so repaid within such period, the directors of the company who are officers in default shall jointly and severally, then it says jointly and individually, jointly and severally, jointly and individually, jointly and severally, will be liable to repay that money with interest at 15% per annum, 15, 15, and then it says 25 and 15. Right? So again, if I look at it logically, one of the things that you need to understand is when I talk about this phrase, jointly and severally, what it means is that, let's say if you are promoters of the company, each one of you hold 10% of the shares, then essentially each of your liability will also be joint in the sense that each one of you will be liable and you are severally liable for the 10% of your holding, right? That's the context. So you're jointly liable because collectively you are liable, and secondly, you are severally liable because each one of you has a particular holding within the company, and that is where severally also comes into the picture. So that's the phrase that you need to understand. So you're liable both jointly as well as severally. So in that context, option B and your option D gets eliminated. Right? Now, technically, because these two options are getting eliminated, 15% per annum is the interest that needs to be paid. Right? And one thing which we need to understand is 15% per month is definitely too much. So that's definitely not a possibility. It has to be 15% per annum as the interest that needs to be paid out in case they do not pay within the allotted time. Now, the second question for you to understand is I'm basically left with option A and E. And what are the key differences here? Sum payable on application is not received, and the option E talks about within 30 days, and sum payable on application is not received. Option A talks about within 15 days. Now, where is the money going to be coming from? So the money is essentially going to be coming from the public in this context, right? So if I go by logic, public needs to be given more time. So ideally, in this case, the public will be given 30 days, and if the sum payable on application is not received within 30 days from the issue of the prospectus, the amount will have to be returned by the company in 15 days. So understand the context, because in the first scenario, the sum payable on application involve the public because they are the ones who need to pay the sum on application, right? And they have to get higher amount of time, so they're getting 30 days to basically pay the amount from the date of issue of the prospectus. When I talk about the company having to return this amount in case the minimum stated amount has not been subscribed, then the company gets lesser number of days, which is 15 days. That's the context So in that perspective, again, 7 is too short a duration. So 30 days is what public gets, 15 days is what the company gets, and in case the company does not repay within those 15 days, then basically a 15% per annum extra liability will be there in terms of interest, and each of the directors of the company will be liable both jointly as well as severally to return the money in case the stated minimum amount is not being subscribed. And by the regulations, the stated minimum amount in the context is 90% for IPOs, right? So that is what section 39 talks about, and the answer in this case is option E, which fits the bill perfectly. Okay, let's move on to the next one now. What does it say? It's again referring to section 39 only, and the question is, which of the following statements pertaining to section 39, return of allotment, is true? Okay, what does it say? Again, looks to be similar statements, so again I have to look at what are the differentiations here. Whenever a company having a share capital makes any allotment of its securities, the company shall, within 30 days thereafter, file with the Investor Education and Protection Fund a return of allotment in the form of PAS 2 along with the fee as specified in the company's registration offices and fees rules 2014. So what are the changes here? The changes are PAS 2 and PAS 3. That's the fundamental change. The other change is 30 days and 15 days. Okay. And the other important change is filing it with the IEPF or filing it with the registrar. Right. So investor education and protection is basically a fund. You will not file any kind of reports with them. The reports will essentially have to be filed with the registrar. So I have to look at options wherein you are filing the return with respect to the allotment with the registrar, right? So which are the options which talk about the registrar? It basically is option D, right? And it's basically option C. Now within these two options, it is already talking about only PAS 3. So which means in the case of allotment of securities by the company, you're looking at the PAS 3 form which gets submitted. And obviously, you know which are the ones that are used in PAS 1 and PAS 2. If you want to jog your memory, definitely go back in the video and check out what I have talked about in terms of PAS 1 and PAS 2, right? So essentially in this case it is PAS 3. So what's the fundamental difference within 30 days or within 15 days? So here again, when I look at it, while I'm tempted to say that the answer should be 15 days by the logic that because it's a company, it should be given lesser time. The point here is that we're talking about allotment of securities, right? So, I mean, if you've undertaken an issue, then understanding which subscribers have subscribed, whether they have subscribed the right amount, whether this person's application form is valid or not, whether they should be allotted the amount or not, and finally the allotment entirely getting audited, and all of these elements do take some bit of time. In this case, basically, because the task is a lot more complicated and the company needs to ensure that the correct information is filed with the registrar, as a result, ideally the company should be given a bit more time, right? Because what is the leg here? The leg here is the interaction between the company and the registrar, okay? Now, if you look at the previous scenarios, it was the interaction between the company and the shareholder, wherein the shareholder should not be made to wait too long. So that is the difference here. And because in this case, the leg is between the company and the registrar, it is okay because there is no public directly involved in this case, and you're talking about the allotments being filed with the registrar. So there is a longer amount of time being provided in this case, which happens to be 30 days. Okay, so that's the context that you need to understand. So here the option is basically option C, which fits the bill perfectly. Okay, let's move on to the next one. Now it basically talks about section 40, which is your securities to be dealt with in stock exchanges, right? Which of the following statements pertaining to section 40 is true is what we're going to be talking about. And if I look at all the statements here, again, they look very similar to me, which means again, I have to focus on the differences between these statements. Okay. So if a default is made in complying with the provisions with respect to securities to be dealt with in stock exchanges, the company shall be punishable with a fine which shall not be less than 5 lakh, but which may extend to 50 lakh. And every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 1 year, right? Or with fine which shall not be less than rupees 50,000, okay, but which may extend to 3 lakh or with both. Okay. Now, here in this case, you're saying if a default is made in complying with the provisions with respect to securities dealt with in stock exchanges. So one thing which we need to understand is that it is not specifically talking about a fraud in this case, right? And because it is not talking about a fraud, any of the options which talk about imprisonment would be too much of a punishment just because you've not been able to comply with the provisions with respect to securities. The options which basically talk about imprisonment will definitely get eliminated because it's not a fraud, it's a default made in complying with the provisions with respect to the securities to be dealt in stock exchanges, right? So as a result, it cannot involve imprisonment as such. Now, what I'm left with is option D and option E. If I look at them carefully, one is talking about 5 lakh, which may extend to 50 lakh, and the other one is talking about 10 lakh, which may extend to 1 crore, right? And every officer of the company who is in default shall be punishable with fine, which shall not be less than rupees 50,000, but which may extend to 5 lakh, right? So technically, there is no hard and fast rule over here. So the way you can remember it is basically, if you remember, we talked about in case of fraud, it was the amount of the fraud and 3 times the fraud. Similarly, the fine is 50,000 and up to 3 lakhs. So, I mean, this is just a way for you to recollect things, right? So it's not 50,000 and 5 lakh, it is 50,000 and 3 lakh. And similarly, 10 lakh and 1 crore is too much of a difference between the company and the fine for every officer. So as a result, it's basically 5 lakh, which may extend up to 50 lakh, and every officer, which may extend from 50 up to 3 lakh. So that is what is the correct option in this particular case. Okay, let's move on to the final question for the day, which basically talks about your global depository receipts, right? So we discussed this in the previous session when we talked about equity markets as well, right? So what it basically talks about is what are the governing guidelines for global depository receipts, right? So in that perspective, this question basically asks you to find which of the following statements with respect to conditions for issue of depository receipts is or are true. So there are 5 statements given. We've got to try and understand each of them. It says the board of directors of the company intending to issue depository receipts shall pass a resolution authorizing the company to do so. Sounds pretty logical. Then it says the company shall take prior approval of its shareholders by a special resolution to be passed at a general meeting. Again, makes a lot of sense. Then it says the depository receipts shall be issued by a overseas depository bank, obviously because your depository receipts have to be in a global location or an overseas location, right? So obviously it has to be a overseas depository bank, right, which has been appointed by the company, and the underlying shares shall be kept in the custody of an overseas custodian bank. Now, I have a problem with this part, so we'll come back to this in a bit. Then look at statement 4. What does it say? The company shall ensure that all the applicable provisions of the scheme and the rules or regulations or guidelines issued by SEBI are complied with before and after the issue of the depository receipts. Okay. Again, I have a slight problem with this one as well. Let's look at option 5 also. What does it say? The company shall appoint a merchant banker or a CA or a cost accountant or a CS to oversee all the compliances relating to issue of depository receipts, and the compliance report taken from such person shall be placed at the meeting of the board of directors of the company or of the committee of the board of directors authorized by the board in this regard to be held immediately after closure of all formalities of the issue of depository receipts, provided that the committee of the board of directors referred to above shall have at least 2 independent directors in case the company is required to have independent directors. Right. So 1 and 2 seem fairly logical. There's a slight complication as far as 3 comes. So while I'm okay that your depository receipt shall be issued by an overseas depository bank, the custody, right, the custody of those underlying shares should ideally be in the domestic country or my country, right? So which is where you're talking about overseas custodian bank being incorrect, and you're talking about a domestic custodian bank in this case, which is where this option basically becomes incorrect. And I look at option 4, it says the company shall ensure that all the applicable provisions of the schemes and the rules and regulations and guidelines issued by the Reserve Bank of India are complied with before and after the issue of the depository receipts. That's the critical difference in this case, because it involves custodian bank and an overseas depository bank. So definitely the involvement of RBI will come into the picture because you're talking about several banks over here, right? The next thing is, when you're talking about the company shall appoint a merchant banker, but when you're talking about a chartered accountant or a cost accountant or a company secretary, it is not only enough for them to be a chartered accountant, it has to be a practicing chartered accountant, it has to be a practicing cost accountant, it has to be a practicing company secretary. That becomes a very key word that needs to be incorporated here. The second problem is when I'm looking at the fact that in case the company is required to have independent directors, then there is no need to have at least 2 independent directors. 1 independent director is good enough, right? So at least 1 independent director should be there in case the company is required to have independent directors. That is where this option also goes wrong. So the correct answer in this case is option C, which is only 1 and 2. And each of the options 3, 4 and 5 have some mistake which needs to be rectified, right? So the correct answer in this case is option C. So I hope you enjoyed this particular session as much as I enjoyed delivering this session for you guys. As I said, one of the critical elements as far as understanding and deciphering the Companies Act is you need to understand the thought process behind a particular element or a particular subsection as to why it is there, right? Obviously, every particular aspect may not be explainable, but there would definitely be some logic behind putting things in a particular way. If you're able to understand that logic, if you're able to correlate one particular subsection or one particular section appearing in some other section, if you're able to understand all of those correlations, if you make the correct linkages, understanding Companies Act will not be that complicated. It's actually quite fun. And when you're talking in terms of someone who's going to be working with SEBI, right, it definitely helps in that context when you understand Companies Act quite holistically, right? It gives you a lot of confidence in all your interactions. Even if you're someone who's targeting the Reserve Bank of India, even then, understanding how companies work, understanding how companies are regulated would definitely help you as a banker also. So in that perspective, definitely Companies Act is something which you should read, and it's not that difficult or not that complicated if you understand the logic behind certain things. And obviously, if you understand things, memorizing them becomes a lot more easier in that context. So I hope you enjoyed today's session, and I look forward to seeing you in another interesting session wherein we unearth some more interesting concepts with questions as the base. So until then, have a great day and a wonderful, wonderful week ahead. See you guys.